Thank you very kindly. I will do part of the reply, then I'll pass over to my senior. And I'm amazed at what level the respondents have gone to misconstrue and misconceive the applicant's case. Your Lordship, in respect to the relationships that were drawn, both for the presiding judge and Justice Mrima, the charge is that of deliberate failure to disclose the relationship. That my lords, you are aware at the time of the inception of the case that Justice Mrima is closely associated to one of the parties, but he deliberately failed to disclose. Equally well, the presiding judge was well aware at the inception of the case that his spouse is greatly connected to some parties in the proceedings, but again failed to disclose.
My Lord, that is new fact. You should not tell which parties. You say clearly, if you can't understand what we are doing, please go to your affidavit and read the affidavit again.
My Lord,
and reply on matters of law. I will not allow you to misrepresent facts. You have an affidavit.
And to embarrass the legal profession.
Yes,
Your Lordship.
You have an affidavit, Mr. Ndegwa. If you can't understand what we are talking about, verbatim, read verbatim from your affidavit.
Your Lordship, may I draw your attention to paragraph 74 of the judgment of the ruling in Navini. The judge says that due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence and the applicants have that will be neutral when it comes to the hearing and the determination of the arbitration. That, Your Lordship, is a confidence that has been eroded. On the question, Your Lordship, on the duty to sit, the duty to sit must be accompanied by transparency and accountability to the parties appearing before a judge. Your Lordship, the duty to sit and the oath of office taken by a judge or a judicial officer must be executed in a manner that breeds confidence to the parties that appears before a judicial officer. Lordship, it's our humble submissions that that confidence has been eroded. Your Lordship, the arguments by Mr. Nyamondi that the parties are forum shopping. Your Lordship, this bench was constituted pursuant to Article 165, Clause 4 of the Constitution, and no petitioner herein has the capacity to direct the Chief Justice who constitutes the bench as to which judge to sit in a particular bench. There is no possibility, Your Lordship, therefore, for an argument that parties are forum shopping. At the inception of the proceedings, Your Lordship, we appeared before you and made arguments comfortably. Little did we know that we would be faced with an application of this nature due to the failure of the honorable judges to disclose those material facts. I invite Kibe to proceed.
My Lord, while during the course of, I guess we've been here for about 5-6 hours when this application has been going on, and there are two things that have been crisscrossing my mind. My Lord, the first issue is the issues of substance and the issue of perception, the optics. What would be the optics, my Lord? The optics, my Lord, as we sit here in public view, in the glare of Kenyans, some of whom, if you use the reasonable test, are professionals, people who